A 9-member bench of the Federal Court today unanimously declared that it is unconstitutional for the Selangor Legislative Assembly to pass a provision to confer judicial review power to the Shariah High Court in the state. Chief Justice Tengku Maimun Tuan said Section 66A of the Administration of the Religion of Islam, Enactment 2003, as it stands, is also unconstitutional. She said the petition filed by CIS Forum Malaysia is allowed and the declaration is granted pursuant to the Courts of Judicature Act. CIS filed the application in the Federal Court on January 21, 2020, after the High Court in Kuala Lumpur dismissed its judicial review application against the Selangor Religious Authority's fatwa labelling the group deviant. Tengku Maimun said that as decided by a number of previous Federal Court rulings, the judicial review power was vested only in the Civil Court. In the Federal List of the Federal Constitution, such power is vested in the Civil Court to check the power of public authorities, she said. Section 66A in its present form, she said, clearly possessed the power of judicial review as intended by the Selangor State Legislature. That was the legislative intent in enacting Section 66A to give judicial power to the Shariah High Court, she said. Tengku Maimun said it was the duty of the Federal Court to strike down the provision and leave it to the state legislature to reenact it in consonant with the state list. CIS went to the Apex Court to challenge the competency of the State Assembly to pass the provision that allows the State Religious Court to review fatwas issued by the state religious authorities. CIS lawyer Malik Imtiaz Sawa said today's decision was extremely important as it made clear the demarcation between the civil courts and the Sharia courts, as well as the limits on the state legislative assemblies when enacting so-called Islamic laws.